Traffic Sergeant Andy Hernandez with a lesson on California driving under the influence laws. Let's start with California Vehicle Code, VC, Section 23-152A. The corpus delicti for this crime is contained in the jury instructions, Calcrim 2110. To prove that the defendant is guilty of this crime, the people must prove these two elements. 1. The defendant drove a vehicle. And 2. When he or she drove, the defendant was under the influence of an alcoholic beverage or a drug, or a combination of an alcoholic beverage and a drug. See Calcrim 2241 for the definitions of driver and driving. A person is under the influence if, as a result of drinking or consuming an alcoholic beverage and or taking a drug, his or her mental or physical abilities are so impaired that he or she is no longer able to drive a vehicle with the caution of a sober person, using ordinary care under similar circumstances. The manner in which a person drives is not enough by itself to establish whether the person is or is not under the influence. However, it is a factor to be considered in light of all the surrounding circumstances in deciding whether the person was under the influence. An alcoholic beverage is a liquid or solid material intended to be consumed that contains ethanol. Ethanol is also known as ethyl alcohol, drinking alcohol, or alcohol. An alcoholic beverage is defined in VC 1009 and the Business and Professions Code Section 23004. Examples include wine and beer. A drug is a substance or combination of substances, other than alcohol, that could so affect the nervous system, brain, or muscles of a person that it would appreciably impair his or her ability to drive as an ordinarily cautious person, in full possession of his or her faculties, and using reasonable care, would drive under similar circumstances. If the people have proved beyond a reasonable doubt that the defendant's blood alcohol level was 0.08% or more at the time of the chemical analysis, you may, but are not required to, conclude that the defendant was under the influence of an alcoholic beverage at the time of the alleged offense. This is referred to as a rebuttable presumption, meaning the defendant can present evidence that rebuts this presumption. If the blood alcohol test falls within the range of 0.05% to just below 0.08, no presumption applies. This means that the defendant is not presumed sober or under the influence. You may still be charged with DUI at this level. The statute also creates a rebuttable presumption that the defendant was not under the influence if his or her blood alcohol level was less than 0.05%. People v. Gallardo, 1994. You will likely not be charged with DUI at this level. In a DUI drugs case, it is not a defense that the defendant was legally entitled to use the drug. If the defendant was under the influence of an alcoholic beverage and or a drug, then it is not a defense that something else also impaired his or her ability to drive. In other words, you can't bring in a defense that they were sleepy, had a medical episode, or some other excuse. The results of a preliminary alcohol screening, PAS test, a handheld blood alcohol testing device, which is typically administered during the standardized field sobriety tests, are admissible upon a showing the foundational elements of properly functioning equipment, a properly administered test, and a qualified operator of the testing equipment. Now let's talk about VC 23-152B, which makes it a crime to drive with a blood alcohol level of 0.08% or more. For this crime, you only need to show 1. The defendant drove a vehicle, and 2. When he or she drove, the defendant's blood alcohol level was 0.08% or more. The difference is that under this section, you do not have to prove any impairment. If the people have proved beyond a reasonable doubt that a sample of the defendant's blood or breath was taken within 3 hours of the defendant's driving, and that a chemical analysis of the sample showed a blood alcohol level of 0.08% or more, you may, but are not required to, conclude that the defendant's blood alcohol level was 0.08% or more at the time of the alleged offense. In synopsis, 23-152A is used for alcohol or drugs or a combo, and 23-152b is used when the person has a .08 or above blood alcohol content. If a person has a .08 or above, the district attorney may charge both sections. What makes DUI a felony? Glad you asked. In California, driving under the influence of alcohol or drugs can be charged as a felony in these situations. It is your fourth DUI within 10 years. You have a prior felony DUI conviction. You cause an accident in which another person is physically injured or dies. Note that fatal traffic collisions will likely result in a charge of manslaughter or murder, which I discuss in another lesson in this class. California prosecutors can charge your fourth DUI as a felony under VC 23-550.5 if you have 3 prior DUI convictions in the last 10 years. Past DUIs include California convictions for DUI, California convictions for a wet reckless, which is when a DUI gets plead down to the lesser charge of an alcohol-related reckless driving, VC 23-103. Any out-of-state convictions that, if committed in California, would be equivalent to a DUI, such as DWI and OUI. DUI causing injury can also be charged as a felony under VC 23-153A. The corpus delicti of 23-153A is 1. The defendant drove a vehicle or operated a vessel. 2. When they drove a vehicle or operated a vessel, they were under the influence of an alcoholic beverage or a drug or a combo. 3. They also committed an illegal act or neglected to perform a legal duty. And 4. The defendant's illegal act or failure to perform a legal duty caused bodily injury to another person. The charging documents will specify the illegal act committed or the legal duty they failed to perform. An act causes bodily injury to another person if the injury is the direct, natural, and probable consequence of the act, and the injury would not have happened without the act. A natural and probable consequence is one that a reasonable person would know is likely to happen if nothing unusual intervenes. In deciding whether a consequence is natural and probable, consider all the circumstances established by the evidence. There may be more than one cause of injury. An act causes bodily injury to another person only if it is a substantial factor in causing the injury. A substantial factor is more than a trivial or remote factor. However, it need not be the only factor that causes the injury. People v. Adams, 1976, DUI cannot serve as predicate unlawful act. The evidence must show an unlawful act or neglect of duty in addition to driving under the influence. People v. Minor, 1994. The term any act forbidden by law refers to acts forbidden by the Vehicle Code. People v. Clenny, 1958. In proving the person neglected any duty imposed by law in driving the vehicle, it is not necessary to prove that any specific section of the Vehicle Code was violated. The neglect of duty element is satisfied by evidence which establishes that the defendant's conduct amounts to no more than ordinary negligence. People v. Oyas. The law imposes on any driver the duty to exercise ordinary care at all times and to maintain proper control of his or her vehicle. Some common defense to DUI are: police lacked reasonable suspicion to conduct a traffic stop and/or lacked probable cause to arrest you. Improperly or poorly administered standardized field sobriety tests, SFSTs. Police received training at the academy and during probationary training on the proper administration of these tests. If the tests were not administered correctly, that could put doubt in the jury's minds. If you were pulled over at an illegal sobriety checkpoint, for example, it lacked the required signage, then any arrests at that checkpoint could be illegal. I spent my entire career enforcing traffic laws, including DUI. I've investigated multiple injury and fatal traffic collisions and seen the damage done to families as a result of DUI. There is no excuse for this crime. Remember that buzzed driving is drunk driving. I'm Traffic Sergeant Andy Hernandez, and that is your lesson on DUI crimes.